Good morning. I'm Father X, talking about how to tell if your divorce court judge is incompetent or gender biased against dads. I have so much to cover. This is part 3 of a 3-part series. In part 1 of this series, episode 7a, we discussed the framework of how to compare the actions of a competent, neutral person versus the actions of your judge. Before we continue, let's quickly review fundamental concepts. The best interests of the mother are to get primary custody of the kids with no questions asked, and then to receive child support. The judge's best interests are met when they create larger child support awards, churn through a large caseload by not asking questions about reality, pretend to make a safe decision by ruling in favor of the mother, which is gender biased. And if the judge is gender biased in favor of mothers, then the judge is achieving their gender biased agenda every time they rule in favor of the mother in a divorce or separation. By the end of our prior episode, part 2, I discussed 13 points where the judge acted in the best interests of the mother and the judge 28 times, and the judge demonstrated incompetence or gender bias against dads 27 times. It's important to learn these tactics used by judges so that you can recognize and counter them if they happen to you. So let's keep going. Point 14. Compare judge to couples counselors overall. As I shared in episode 6a, before we ever got court involved, our son's mother and I went to 3 different counselors to deal with our conflict. Each one used the same process. They met with us for an hour at a time every week or 2. They spoke to us together and separately. They listened to both sides of our story. The counselors listened to my complaints about the mother's violence. And within 2 months, they each independently concluded that the mother had anger management problems, impulse control issues, and that she was the violent one in our home. And the mother probably had bipolar or borderline personality disorder. In contrast, let's look at the judge's process during temporary custody orders for 3 years. The judge didn't speak to the mother or I during the pretrial process to figure out the actual facts of our case. The judge didn't ask any questions to clarify who the perpetrator of domestic violence was. The judge ignored everything my lawyer or I said in court or alleged in our petitions. The judge kept issuing orders rubber stamping the mother for temporary primary custody. The judge never demonstrated any understanding of bipolar or borderline personality disorder, but that was a key part of this case. And the judge demonstrated no understanding of the risks to a child of living with a bipolar or borderline parent. Do you see how inferior and incompetent the court's process is? So let's mark another example of the judge acting in the best interests of the mother and of the judge. And let's mark one more example of the judge's incompetence. Point 15. Compare judge to couples counselors, our second couples counselor. After our late November appearance, we had been to court 4 times. I spoke to our second couples counselor one-on-one while this court stuff was happening. This counselor had met with both me and the mother in real life before court and was aware of the mother's psychological issues, her violence, manipulation, and threats. When I told him the court gave the mother custody 5 out of every 7 days and that I could only see our son on weekends, this was his reaction. It's well known that fathers have a much bigger impact, positive impact, on a child's psychological, intellectual, and emotional development. It's important that you be deeply involved in your son's life. His mother will hurt him psychologically as he grows up, and as she does, you have to be the one that shows him a different way. And you can't undo that psychological damage if you only have custody 2 days a week. Wow. Compare that analysis to the judge who rubber-stamped the mother for custody with no questions asked. So for not engaging in any competent analysis, let's mark another instance of the judge acting in the best interests of the mother and of the judge. And let's mark one more instance of the judge's incompetence. Point 16. How the judge picks the forensic evaluator. In December of year 1, the mother and I each had to submit names of 3 potential psychologists to do the job, and the judge chose one of the mother's options. I have no idea what the judge's experience was with any of the 6 proposed evaluators, nor do I know the history of these psychologists. However, the fact that she chose one of the mother's options gave me the sense that the judge was again providing preferential treatment to the mother. It's possible the judge chose a psychologist she believed would be fair to both parents. However, if the judge wanted to be fair to the father, the judge would have given me 50-50 custody from the start, as I asked for many times. The greater likelihood is that the judge chose the evaluator most likely to be beneficial to the mother. Second, I discussed in episode 6D that the judge decided the father should pay 85% of the forensic evaluation costs, instead of splitting it equally, as I suggested. It was obvious neither parent could afford the cost of the forensic evaluation, but the judge gave the overwhelming burden to the father and created obstacles for the father while making it easier for the mother to proceed. The judge provided no reason at all as to why the father should pay 85% of forensics, but any competent professional would have provided a reason to justify that decision. So, for her handling of the forensic evaluation, let's mark another 2 instances of the judge acting in the best interest of the mother and of the judge, and let's mark 2 more instances of the judge's incompetence. Point 17. Preventing the forensic evaluator from making custody recommendations. My judge ordered that the psychologist was there to evaluate the parents, but the psychologist was not allowed to make an actual child custody recommendation. Judges and lawyers might claim, the forensic evaluator shouldn't make a custody recommendation because that's the judge's job. Is this intelligent thought? No. Why? Because psychologists routinely deal with family relationships and child development. In terms of intelligent analysis on this matter, most psychologists can run circles around most judges. As a starting point, if your goal was to create a competent family court process, you would encourage input from competent professionals about custody arrangements to be included in this discussion, instead of just one opinion from one judge. That would be a better process. And if the judge disagrees with the psychologist's custody recommendations, the judge should provide competent analysis as to why the judge's opinion is better than the psychologist's opinion. I concluded the judge wanted to be the only one on the record to make a custody decision without being contradicted. This would enable my judge to freely make gender-biased decisions. Also, if this case was appealed and the appellate court saw that the forensic psychologist disagreed with the judge's predetermined opinion, that could increase the possibility that my judge would be overturned on appeal, which judges hate. So, for blocking the ability and possibility that a psychologist could undermine the judge's predetermined outcome, let's mark another instance of the judge acting in the best interests of the mother and of the judge. And let's mark one more instance of the judge's incompetence. Point 18. More hollow speeches from the judge. When we went back to court in January of year 2, there were fireworks when my lawyer and I exposed the judge's ongoing incompetence and gender bias. My lawyer launched into it, saying, "There has been a modification among the parties for 3 separate weekends for the father to have the child from Sunday night to a drop-off Monday morning. We're asking the court for that to be the court's order at this point for every weekend. There is no reason for my client not to have more time with the child. The initial rationale for the child staying with the mother throughout the work week was that she wasn't employed, and that my client was employed, and that the child should be with a parent who wasn't employed. That has already been and continues to be a faulty argument. So we're asking the court to modify its order with a pickup at 6 p.m. on Friday and drop off at 8 a.m. on Monday morning to the mother." The mother's lawyer shot back, saying, "Every time we come into court, there's an application to change the interim order set by the referee, and I believe Your Honor has made clear that the procedure would have been to go forward with the forensics and hope that the issue is resolved that way. I would submit that there's no reason to make that change." But the mother's lawyer was wrong. It was obvious that she just wanted to have the court rubber stamp the mother for primary custody as long as possible. There was a reason to make that change. That reason is the law, which states both parents have equal rights to their child, and the best interests of the child would determine if one parent should be the primary custodial parent. And there still had never been any discussion at all about the best interests of our son. And my lawyer replied with, My client has asked for more time on every court date and will continue to ask for more time. We're seeking a certain level of fairness that has been absent." And the judge quickly replied, "Pardon me? Fairness has been absent? Let me just stop you 1 second. This court has heard the respective parties' positions, and the child isn't an object to be split down the middle. Obviously, there has to be some give and take with respect to the child's best interests and parenting time. I don't understand the statement that there has been lacking fairness in this process. From what I have observed with respect to how I see the parties, I would disagree with that statement. I'm not going to change the arrangement of parenting time simply based upon counsel's oral application. I'll have a full hearing with respect to all of the issues and make determinations after I review the credibility of the parties and any other witnesses that might be presented. So if there's no agreement with respect to changing this access schedule, I'm not going to do it absent a hearing." Do you guys notice what I noticed? First, we challenged the judge's fairness. She got angry and yelled at my lawyer, but the judge still avoided any mention about how it was in the best interest of the child to primarily live with a violent, knife-wielding, suicidal, borderline mother. The judge still ran away like a coward from that topic. Second, there's obviously a lack of fairness when both parents have equal rights, but the judge is rubber stamping the mother without any fact-finding for no legitimate reason. If the judge doesn't understand that's unfair, then the judge is a moron. Third, when the judge talks about what she's observed and how she sees the parties, that doesn't mean anything. She never said what that was. She was hiding from stating what she thought reality was, because then we could attack her false beliefs. So she kept her statements vague and cryptic. Fourth, when she referred to splitting our child down the middle, she was referring to the King Solomon Bible story about cutting a baby in half. But we weren't talking about cutting our child in half. We were talking about equal parenting time. And even if you can't cut a baby in half, that doesn't mean the mother gets primary custody. So that entire reference was idiotic. And when she talked about give and take, she was trying to give the illusion that she was balancing the rights of all parties. But obviously she wasn't, because to this point, only the father was giving and only the mother was taking, per the court's orders. This tirade by the judge showed me that she was a total moron. I designed my 28 hours of testimony knowing that it was for a mentally handicapped judge who had no idea how to make decisions in the best interests of the child. So let's mark another 4 instances of the judge acting in the best interests of the mother and of the judge, and let's mark 4 more instances of the judge's incompetence. Point 19. Look for patterns in the judge's other cases. When I sat in the courtroom the first 6 months, I didn't just focus on my case. I listened to about 30 appearances of other parents. 30 is a significant number. In 100%, not 90%, but 100% of those cases, it was the mother who had custody of the children. That signaled to me that this judge only rules in favor of mothers. I could possibly believe maybe 60% of these moms could have truly been a better parent, but 100% is not even close to credible. So, for demonstrating a pattern of gender bias in her overall caseload, let's mark another example of the judge acting in the best interests of the mother and of the judge. And let's mark one more example of the judge's incompetence. Point 20. Always siding with mom and demoralizing the father. If you look at each judge I encountered, you see a pattern that every decision was in the best interests of the mother, never of the father and not of the child. It seemed like every family court practitioner had a default starting point, that any time an issue arose, they would decide that one issue in favor of the mother. After 10 appearances, you might have 10 decisions in favor of the mother and none in favor of the father or child. The judge is supposed to be like a neutral mediator. But no competent mediator would exclusively take the side of one party on every issue. If you're a father and you see this pattern, you learn the court is always going to rule in favor of the mother. It demoralizes you and makes you quit the fight and settle for being a non-custodial parent, because there's no point in fighting against this bias. And if you settle out of court, then it's your decision to give the mother primary custody, and not technically the judge's decision. But the judge is the one who created the oppressive circumstances to lead to this bad settlement. So for ruling in favor of the mother every time, so the father gets demoralized and quits, let's mark another example of the judge acting in the best interests of the mother and of the judge. And let's mark one more example of the judge's incompetence. Point 21. How judges conduct proceedings. Talking to lawyers only. The judge has to decide which parent is better suited to meet the needs of the child, or if they can be equal co-parents. But when lawyers are involved, the judge addresses the lawyers, and the parents rarely speak. This is an inferior and incompetent process. The judge is deciding if the parents are fit, not the lawyer. Why wouldn't a judge focus on speaking to the parents? You can have a lawyer who's a good public speaker covering up the parents' craziness. My son's mother only began to speak in court after a year and a half when she was testifying, and only after that did people begin to realize she was crazy, and her stories of being a domestic violence victim didn't even make sense. But that was covered up for 2 years because the judge never spoke to her directly. So, for having a process that ignores the character and personality of both parents for so long, let's mark one more instance of the judge's incompetence. Point 22. Compare to professionals, child psychologist and mediator. When the mother and I tried to mediate, the mediator was a child psychologist, a man in his 50s with extensive experience in child development. This man didn't know us and didn't have any proof of the domestic violence or mental health issues alleged by each parent. So he was uninformed about the reality of what happened in our home. He was just like the judge in that regard. But during mediation, he told us that a child between the ages of 0 to 4 years old, like our son, should not go more than 3 or 4 days without seeing the other parent. He said doing so would negatively impact the child's development. However, what did our judge decide? She decided the child should be with the mother for 5 days, and 2 days with the father, and 5 days again with the mother, for 3 years, which directly contradicts the analysis of this child psychologist. Was this judge acting in the best interests of the child's development? No. Let's mark another example of the judge acting in the best interests of the mother and of the judge, and let's mark one more example of the judge's incompetence. Point 23, the final custody order. It could be said that because the judge made a final custody decision in the best interests of the child and awarded me custody, that this is a point in favor of the judge acting in the best interests of the child and acting competently. However, I won't credit the judge for that. Why? Because for 3 years, the judge constantly ruled against me and rubber-stamped the mother. I got to this point because I outmaneuvered the judge using appellate law and 28 hours of testimony designed to undermine the bigoted stereotypes of the judge. Therefore, she gets no credit. Based on these 23 points, the court acted in the best interests of the mother 40 times, in the best interests of the judge 40 times. And we can see the court demonstrated incompetence or gender bias 40 times. Obviously, the divorce and family court system is broken if you have to work around this dysfunction to save your children from the court's incompetence and gender bias. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position. Also, if you find this information helpful, please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.